Now, in other words, our anchor submissions on the preliminary points, which in our respectful submissions are completely insurmountable, is the issue of jurisdiction and then the issue of condonation stroke agency, as we discussed before lunch. Now, to transition to the merits, I'd like to read at page 198 of the papers. Because this is what they say their case is. I was going to start at paragraph 20, but I've already made that point. That's the point about hearing for the first time on 7th of January. Then they said paragraph 21 at the bottom. The ANC, this is now the ANC itself, Mr. Mbalula's affidavit. The ANC is not reviewing the Electoral Commission's decision that it had taken on appeal. The ANC's appeal dealt with the Umkhonto Wesizwe's registration as a political party as a violation of the Electoral Commission Act due to its causing voter confusion. That's Justice Adams's point. And this is the important part. That decision is not being reviewed before this court. This court is called upon to review the decision taken by the Deputy Chief Electoral Officer to register Umkhonto Wesizwe Party on 7 September 2023 in circumstances with us to the merits. Assume everything we've said about the preliminary points will be found against us. Now, what have we got really here? Again, it's one of those things. Once you unpack it, you really see there is no case whatsoever. It was one of those situations where we must just do something. Just shoot in the air, maybe some bird will fly, will fall down. Entire case on the merits is that the letter at page 44 of the papers of the 4th of August was a letter that was given an instruction, a direction, compulsion, whichever word you can use, for the submission of the so-called fresh application. And I'll come to that just now. Now, Ndumeni tells us that you can't just pick words, one word, fresh, and then another word, rejection, and then you say, there you are, let's go to the dictionary. It doesn't work like that. Statutory interpretation or interpretation of any legal instrument for that matter, including that letter, is according to Ndumeni and the constitutional court cases that followed it, based on 3 things. Text, context, purpose. That is the magic formula for interpreting legal documents. What does the text say? Then you can deal with dictionaries and what have you and so on. But what is the context and what is the purpose of the instrument? Now, we have one of the strangest phenomena in legal history, where you have 2 parties to a letter, let's call it like that, or a contract in loose terms, to an agreement that's contained in the letter of the 4th of August. The party that sent the letter and the party that received the IEC, and Umkhonto Wesizwe tells you how we understood the document. So those 2 parties who are the primary players in this document are ad idem. A 3rd party somewhere in the street comes and says to the court, no, those 2 parties, although they are agreed, one says we did not intend to make it a non-supplementation clause. The one that received it says we also did not understand it like that. But some 3rd party walking in the street says, no, they are both wrong. They are both wrong. We have another interpretation of what it is that they were communicating about. Can be. Ndumeni tells us that one of the key, at paragraph 18 of the Ndumeni case, one of the considerations in interpreting any document is the surrounding circumstances and the history and the author of the document. What it is that, because the test is not subjective, it's objective. The court looks at the instrument, looks at the surrounding circumstances, and it says what is the meaning, yes, not the old test of the intention of the parties. This is a standard letter, definitive. A completely different application, that's also fine.
So
But-
would it be fair? Would it be fair for, an onlooker to say whether it was supplementary or it was a fresh application or an old one retrieved, there was an application before the CEO?